Hey, greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. We're talking about informed use of credit again tonight. We kind of touched on it yesterday with the congressional purpose, and we're going to go over that again tonight. But first, we're going to get into basic obligation of public service, which we also went over, and I want to get into a little more detail on that. So we're going to do that first. Panel link is down there for anybody who wants to join the panel. Feel free to join. And as we see, it's Title V of the Administrative Personnel, Office of Government Ethics, Standards of Ethical Conduct for Employees of the Executive Branch. And what we're hopefully going to be able to show to you tonight is that conference of a nationality known as a United States citizen upon enumeration at birth is a placement in a record of an individual under administrative personnel. And remember, folks, with that enumeration at birth, that is the assignment of a number to a name. That name is a translation of the given name and the family name by the Social Security Administration. So that's their creation, and they attach their number to it. That is the creation of that United States citizen as an individual. And we're going to see that too. It says public service is a trust, a public trust. So whenever you see a service contract, again, I'm telling you, all contracts are of a public trust source, unless it's a private contract. So any kind of public service you get, whether it be a grocery store, mom and pops, a little United Way program, those are all public services, and they operate in a public trust. And in order to do so, each one of them must have a contract to do so. Each employee has a responsibility to the United States government and its citizens. And what I want to point out here very distinctly, that's naming three parties. Again, it's a trust. And they have an obligation to the party that granted them their powers, which is a grantor, and they are operating as a public servant in the public trust, and its citizens are the benefactors. It is the expression of a trust. The trust instrument is mentioned next, and it is their contract. Remember, it's a global postal trust services, and that has a constitution itself. The Constitution of the United States is a contract within that Constitution, also called a constitution. To place loyalty to the Constitution's laws and ethical principles above private gain. That's distinguishing no matter what your private elements are in that check that you receive. You are obligated to a superior source known as public trust in your public service, to ensure that every citizen can have complete confidence in the integrity of the federal government. Each employee shall respect and adhere to the principles of ethical conduct set forth in this action, as well as implementing standards contained in this part and in supplemental agency regulations. First, let's look at federal government. As I said, from 5 CFR 575.102, and I've quoted it many times. And you can see as I look at the screen here, let me do this. I'm not even going to look at the screen. I'm going to tell you verbatim. The federal government means all entities of the government of the United States, including the United States Postal Service and the Postal Regulatory Commission. That's government of the United States. The United States is a corporation. And so all entities of that corporate government entity itself are corporations as well. Just like they have to follow the Constitution of the United States, it is just a sub-constitution of the Constitution of the Universal Postal Union. Those contracts under that federal government are such things as well. They constitute the terms and conditions that they are bound by. Understand these words. So let's go back and look at the next one. Each employee shall respect and adhere to the principles. Remember, this is the one we read yesterday, and it's got an error. This here is a statement. That's the definition of employee. Then they start out and they restate the exact same thing again, and then they turn around and restate this part for a third time. So again, their competency seems to be a little lacking. If some hick born on the mighty Mississippi with mud squishing between his toes that acts like Tom Sawyer and didn't do anything but graduate high school can recognize their own error, and they put this in the public after it's been proofread. Again, the importance of proofreading. And it says, means any officer or employee of an agency. Remember that resident? No person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. So let's go back and look at states. We've seen this one before. It says state means a state, the District of Columbia, or any territory or possession of the United States. That's 18 U.S.C. 7, special maritime and territorial jurisdiction of the United States, meaning they have to have a contract that has obligations and other securities of the United States for funding those contracts. And Article 18 U.S. Code 9 is pursuant to vessels of the United States. And each state is a vessel of the United States, since they ceded their jurisdiction to the United States for that corporate veil. Agency means an executive agency or legislative branch agency included in 5 U.S.C. 5102(1). Let me pull that up. 575.102(1). Make sure that's correct. 5102, Section 1. The first appointment, regardless of tenure, as an employee of the federal government, and this is according to a newly appointed enumeration at birth, wherein, like I said, you can check with the Social Security Administration by filing for disability, and then when they do the intake on you, asking for the accounting of that, and on that it should have MQC, Medicare Qualified, MQGE, and ask them what it stands for. It's Medicare Qualified Government Employee. So when you go in to apply for a disability, that record will show that they've been treating you all along as if though you're a Medicare Qualified Government Employee. And that's from the day you are born, unless you rebut it. An appointment of a former employee of a federal government following a break in federal government service of at least 90 days. An appointment of an individual. Remember that individual term. in the federal government when his or her service in federal government during the 90-day period immediately preceding the appointment was not in a position excluded by 575.104 and was not limited to one or more of the following: competitive or accepted service, competitive or accepted service, employment with the government or DC, an appointment as an expert or a consultant. They must consult with you for the private data elements, folks. You are being treated as a consultant. Employment under a provisional appointment designated under 5 CFR 316.403. Employment under an intern program. What do nurses and doctors do? They go through an intern. What do they call it? Residency. Employment as a senior executive service, limited term appointee or limited emergency appointee. So those terms don't matter so much as the individual that is newly appointed upon enumeration at birth as a resident, United States citizen, and a Medicare qualified government employee. That's a goddamn awful lot of fucking presumptions, folks. So let's go back. General principles. Oops, where'd I go? There we go. General principles. The following principles apply to every employee and may form the basis for the standards contained in this part. Where a situation is not covered by the standards set forth in this part, employees shall apply the principles. That's you. You're supposed to apply these principles. If you don't apply these principles, then they're going to misapply the standards because that's what you're qualifying. There is a distinct variance from categorical pretreatment standards that are fundamentally different in nature. Remember that statement. Go back and clip this if you need to. Set forth in this section in determining whether their conduct is proper. So it's much like policing yourself. Yes, I investigated myself and I found myself not guilty. Does that sound familiar? Because that's what's happening today, folks. Hitler's willing executioners. Public service is a public trust, requiring employees to place loyalty to the Constitution, the laws, and ethical principles above private gain. Employees shall not hold financial interest that conflict with the conscientious performance of duty. I'm just doing my job is the very indication that they are violating this. They are applying the standards of pay rate to just do their job and not apply the principles. Employees shall not engage in financial transactions using non-public government information. If it's private, then it's non-government. Period. If it's government information, it's private or public, excuse me. All government information is public, except for those who have personal identifications that are classified because they are, in fact, federal, state, or municipal officers or agents whose resident presence is deemed necessary but confidential. If it was non-public government information, as I said, private, then why are all of these public information centers exchanging all of those private data elements? Or allow the improper use of such information to further any private interest. Again, it's going to fall back on you. You're the one giving them the private data elements in their public government information system known as their records. An employee shall not, except as permitted by subpart B of this part, solicit or accept any gift or other item of monetary value from any person or entity seeking official action from, doing business with, or conducting activities regulated by the employee's agency, or whose interests may be substantially affected by the performance or non-performance of the employee's duties. Again, the competence of the doctors when it comes to spiritual credit is zero. If they're taking a Hippocratic oath to Apollo and the Greek gods, and you profess to be a Christian, you are effectively denying your God and letting their gods of 12 emotions rule over you. And therefore they enter you into a spell of illness and start propagandizing public education institutions of fear that if you don't remember this, you will be a loser in life. Sickening. It's plain writing, folks. Employees shall put forth honest effort in the performance of their duties and not get caught up in their emotions. Employees shall not knowingly make unauthorized commitments or promises of any kind purporting to bind the government. That's the obligations of debts. That's a bind of the government. They're the ones obligated for all debts. And when these people believe that they have to do that paperwork the way they've always been doing it, because that's just their job, and it's binding the government in a debt, don't you get it? Employees shall not use public office for private gain. So what are those paychecks? Oh, wait a minute. That's not actually considered private gain, folks, because their estate, unless they've corrected it and have established their own private trust, proving that they can't be a government employee, and thus they can only be an outside contractor as a consultant giving information. That's a government contract with government pay. It's not for private gain because it's a probated estate. It's not your living will. If it were your living will, it'd be for private gain. Employees shall act impartially and not give preferential treatment to any private organization or individual. So as an individual, you're treated as every other employee, as that term is defined. And that's because you keep placing the presumptions on that record instead of rebutting them. Mom placed the initial one that you were born in the United States, and there's no such record because you were truly born in the state, and the record will reflect that. But at the same time, the state claimed that you are a resident, a federal, state, or municipal officer or agent whose resident presence was deemed necessary, and indoctrinated you through public education to give a name and address and be able to sign it without teaching you how to qualify that signature on credit. They never informed you in use of credit. They never gave you informed use of credit. Employees shall protect and conserve federal property and shall not use it for other than authorized activities. And if you can't use the federal government property in such ways, then you're not authorized to use private property either. Keep your filthy hands off the people's property. Filthy people, clean up your property and quit giving it away. Employees shall not engage in outside employment or activities, including seeking or negotiating for employment, that conflict with official government duties and responsibilities. That's that Constitution. You can't conflict with the Constitution, folks. Doesn't matter if you're an administrative law judge and want to sit on a bench and say the Constitution doesn't apply here. The fuck it doesn't. Employees shall disclose waste, fraud, abuse, and corruption to appropriate authorities. Again, American citizens would report that to American Citizen Services and the Department of State and the Attorney General and many others up and down the line. You're going to scream it at the top of the world, speaking boldly as you ought to. Employees shall satisfy in good faith their obligations as citizens themselves, including all just financial obligations, especially those such as federal, state, or local taxes that are imposed by law. And that is the disposition or deposition that you take upon that citizenship, is the imposition of taxes, whether they be local, state, or federal. Federal, state, or municipal officers or agents. Don't you get it? Employees shall adhere to all laws and regulations that provide equal opportunity for all Americans. What happened to United States citizens? They cannot exclude you. 42 U.S. Code 2000D. Prohibition from exclusion of benefits, federal government benefits, regardless of race, color, religion, sex, or national origin, age, or handicap. And like I said, I'll look up that term, handicap, one of these days, and we'll do something on that. Employees shall endeavor to avoid any actions, not evade, avoid. Avoidance is perfectly lawful. Evasion is not. Any actions creating the appearance that they are violating the law or the ethical standards set forth in this part. This is the importance of giving them notice. Hey, you're violating the ethical standards, which is a tort in law. Whether particular circumstances create an appearance that the law or these standards have been violated shall be determined from the perspective of a reasonable person with knowledge of the relevant facts. So you have to come forth with the knowledge of the relevant facts, because they are relative, because you are the relator, the benefactor to the beneficiary. You are the next of kin, and it is relative. And it's only your knowledge that can fix that record. Only you can come out of the employee capacity in recognition that it is impossible or that you have not completed the qualifications to be such an employee. Then the related statutes, in addition to the standards of ethical conduct set forth in this part, there are conflict of interest statutes that prohibit certain conduct. Criminal conflict of interest statutes are criminal conduct. It's criminal to misapply the data elements that I'm trying to correct. It's criminal to tell me that I cannot correct the lease agreement and let you people know that I am only temporarily dwelling and not a resident of any sort, temporary or permanent. I am no such thing. I am not a tenant. I am not an occupant. My companion is not an occupant. She has no longer got an occupation. She is retired. These terms no longer apply. And if you misapply them, that's a 30-year sentence. I'm giving you notice. It would be criminal. And though, of course, if you look at those 18 U.S.C. 201, 203, 205, 208, and 209, you'll see they have to do with public servants. Are summarized in the appropriate subparts of this part and must be taken into consideration, equal benefit in all contracts of public service, because you are the public trustee and required to assist the benefactor to receive his benefit. You cannot exclude him or his corrections. You must assist as it goes to the integrity of that record. In determining whether conduct is proper, in person, or the private capacity of the benefactor that gives to the person known as the beneficiary. Citations to other generally applicable statutes relating to employee conduct are set forth in subpart 1, and employees are further cautioned that there may be additional statutory and regulatory restrictions applicable to them generally or as employees of their specific agencies or as employees of their specific agencies. Specific or general. And there is a special exception that prevents them from excluding us, and that is the title American. Because an employee is considered to be on notice of the requirements of any statute, an employee should not rely upon any description or synopsis of a statutory restriction, but should refer to the statute itself and obtain advice of an agency ethics official as needed. Agency ethics official refers to the designated agency ethics official or to the alternate designated agency ethics official referred to in 2638.202b of this chapter, and to any deputy ethics official described in 2638.204 of this chapter, who has been delegated authority to assist in carrying out the responsibilities of the designated agency ethics official. American Citizen Services. I hope I've still got everybody. I want to say thanks for everybody's support. We got Daddy's Flying Money Bag. Greetings, brother. Always good to have you. Amazingly Illuminated, the producer Moose, Unite and Create for Life. Norm Longstaff, Josh Jonio. We got Laura, Yes M, Rebel Studio 2, Lex Animata. Who else? Rollum 024, greetings. Anybody else that I didn't see, please feel free to make a comment. And of course, the panel link is down there. I'm going to drop it again, just in case anybody wants to join the panel. The Rich Man Ice. Good evening, brother. How you doing? I always appreciate the information and your take on it, brother. I always appreciate your take too, man. I always appreciate it. A brother from Lawful Living, one of our other groups. And of course, there's PayPal link in the details section for anybody who wants to share some love. And let's get back at it. The next one is at 575.102 definitions, where again it says agency means an executive agency or a legislative branch agency included in 5 U.S.C. 5102A1, which we'll take a look at. Authorized agency official means the head of an agency. Okay? The head of an agency, or an official who is authorized to act for the head of the agency in the matter concerned. And if you remember, Rich Mang, in Lawful Living, we went over the issuance of going to the head of the agency, not an official who is authorized to act for the head. They are an actor, okay? They are not officially designated as the head of the agency, and so we cannot go to those folks in those administrative courts as heads of agency. And I'll show you why here after this set of definitions. One of my favorites, competencies, means the knowledge, skills, abilities, behaviors, and other characteristics and individual needs to perform the duties of a position. And again, it comes down to the words, folks. Employee has the meaning given in the term given that term in 5 U.S.C. 2105, except that the term also includes an employee described in 5 U.S.C. 2501 or 2105C for the purpose of determining whether an individual was an employee of the federal government during the 90-day period referred to in definition of newly appointed employee. Also includes an employee described in 5 U.S.C. 2105E for the purpose of 575-109D. An employee means an individual not yet employed who has received a written offer to be newly appointed or reappointed and has signed the written service agreement. The SS5. That's a service agreement. Not a credit agreement. Someone forgot to amend the service agreement to a credit agreement. Or didn't know. Didn't have informed use of credit to tell them. Required by 575.110 before payment of a recruitment incentive. Again, folks, it's all military. If you don't believe me, Article 10 of the Labor Code. Read it until you memorize it and understand. Martial law chiefly affects the police and the collection of public taxes and revenue, whether by the expelled army or expelled government or the invading forces, and for the use of the army, its purpose or its benefit, and the safety of its operations. Executive agency has the meaning given that term in 5 U.S.C. 105. Federal government, again, means all entities of the government of the United States, including the United States Postal Service and the Postal Regulatory Commission, as we quoted earlier. And remember, folks, United States Postal Service is the registered agent of the Global Postal Trust Services. Newly appointed refers to the first appointment, regardless of tenure, as an employee of the federal government. The first appointment would be SS5. There is an assignment of a number to a legal name that is presumed to be a federal employee, a Medicare qualified government employee at one level or another, whether he's the head of the agency or otherwise designated through a state or municipality. An appointment of a former employee of the federal government following a break in federal government service of at least 90 days. An appointment of an individual in the federal government when his or her service in the federal government during the 90-day period immediately preceding the appointment was not in a position excluded by 575-104 and was limited to one of the more following. Again, all them competitive contracts, and of course, appointment under as an expert consultant. And then we continue on with 5, employment under a provisional appointment, employment under an internship program, employment as a senior executive service. OPM means Office of Personnel Management. Rate of basic pay means the rate of pay fixed by law or administrative action for the position to which an employee is or will be appointed before deductions and including any special rate under 5 CFR Part 530, Subpart C, or similar payment under other legal authority in any locality-based comparability payment. Your ability to compare coffee beans, say, 1,843, and we'll say 44 coffee beans, and you can keep the change for each one being a portion, the full portion of $1 for that $1,843.72 bill. You can keep that other 28 cents worth of bean. Similar payment under other legal authority, but excluding additional pay of any other kind. Do you guys know that there's an additional pay when you're using fractional reserve notes? It's called a millage rate. It's called using the other side of the decimal. So when you get a $10 bill, in fact, it's only 10 cents. When you get a $100 bill, in fact, it's only 1 cent. It says dollar for dollar, not $10 for $10, you dummies. For example, a rate of basic pay does not include additional pay such as night shift differentials or environmental differentials. Service agreement means a written agreement between an agency and an employee, under which the employee agrees to a specified period of employment of not less than 6 months or more than 4 years with the agency in return for payment of a recruitment incentive. Everybody still with me? Greetings, Dragonfly Vision. Glad you joined us. And one quick reminder, hit that like, share, and subscribe buttons. The next one we're going to look at, this is something that we discussed on Lawful Living today about the judicial access to the courts. And like I said, Rich Mang, it's about contacting the head of the agency. So please pay attention. The Judicial Officer Department is a neutral, independent forum within the United States Postal Service, comprised of the judicial officer, the Office of the Administrative Law Judges, and the Postal Service Board of Contract Appeals. This is a judicial notice of judicial obligation. The Judicial Officer Electronic Filing System is where you can file a new case, ask to be added to an existing case. In those administrative courts, they're operating as a probate. You have no say in those courts, and they're not listening to you because you're not on the case. Scott versus McNeil. The administrative courts have no jurisdiction over the estate of a person who is in fact alive. Or work with cases in which you are already a party or representative. I am the benefactor to the beneficiary, which they are administrating as a defendant. Postal Service Board of Contract Appeals. Chairman, Judge Alan R. Carmella. Administrative Judge, Board Member, Judge Catherine Crow. That's a board member. Who do you have to go to hire an attorney? The Board of Directors. Administrative Judge, Board Member, Judge Diane M. Mago. Administrative Judge, Board Member, Judge Richard Rowe. The Postal Service Board of Contract Appeals has jurisdiction to consider and decide any appeal from a decision of a contracting officer of the United States Postal Service or the Postal Regulatory Commission relative to a contract made by either. United States Postal Service has the Real Estate Investment Trust, and that is the very reason they have a number attached to a street name security created by a local municipality that named the street. They are investing in a real estate investment trust. In that, they have a contract with the municipality, and they are both misapplying the address because you are. Postal Service Board of Contract Appeals decisions. Decisions and non-presidential substantive orders. This is outside of case law. Case law is precedent. This is non-precedent. Substantive orders of the Postal Service Board of Contract Appeals and the board's rules of practice are available online. And you can click right here and open up rules of practice. This is not the rules of the administrative code. This is rules of the judicial practice, procedures. Judicial Officer and Office of Administrative Law Judges, the agency, the heads of agency. I hope you're still with me, Rich Mang. Judicial Officer, Judge Alan R. Camella. Associate Judicial Officer, Judge Diane M. Migo. Chief Administrative Law Judge, Judge James G. Gilbert. Administrative Judge, Judge Catherine Crow. Administrative Judge, Judge Richard Rowe. The Judicial Officer and Office of Administrative Law Judges perform quasi-judicial duties as designated by the Postmaster General. Now tell me if the administrative law judges are operating under the United States as a corporate entity or by the Postmaster General under the Postal Regulatory Commission. Postmaster General and the Postal Regulatory Commission, those are the military terms. That's Admiralty. United States is maritime. Applicable statutes and regulations. The judicial officer is the agency for the purposes of Chapter 5 of Title 5. To the extent those functions are delegated to him by the Postmaster General. Decisions and non-presidential substantive orders of the Judicial Officer and Office of Administrative Law Judges, along with the applicable rules of practice, are available right here. Versus McNeil. Look that up and just tag um, Library of Congress with it. And that should pull up Scott versus McNeil, and you will see it reiterate that same phrase in like wording several times. Greetings, Russ. How you doing tonight?
Greetings, brother. Good. Figured I'd jump and sit in for a little bit.
Awesome. Always glad to have you. And again, folks, the link's down there for anybody else that wants to join. Let's get back to it. The next one, that 5 U.S. Code Chapter 5, Administrative Procedure. As we see here, this is Chapter 5, Administrative Procedure. And it's got the general provisions 500 through 504. Then they've got the administrative procedure 551 through 559. So let's look at the administrative. Let's go back. Let's go ahead and take
a the background or something.
Say what?
I think they get a better view of the screen if you put us in the background.
Yep. Thank you.
Yep.
And so let's take a look at the provision. It says administrative practice. Look at the next one. Advertising practice. Administrative practice, reserves and National Guard. Witness fees and allowances. Costs and fees of parties. So they're talking about commercial things here, right? Administrative procedure. Definitions. Public information, agency rules, opinions, orders, records, and proceedings. And once again, I remind you, we still have no law. Okay? 552A is the one we're going to look at here, because this is the records maintained on individuals. Now, this is a long section here, and I'm not going to sit here and read the whole section, but I am going to read a portion of it here at the beginning to get some concept over to you guys. For purposes of this section, the term agency means agency as defined in section 552E. Remember the definition that we saw in 575.102, the CFR, and it directed us to this one here, and it directed us to several others in that 552 section. We're going to look. The term agency means, of this title, the term individual means a citizen of the United States. You guys catch that? Records maintained on individuals. Means a citizen of the United States or an alien lawfully admitted for permanent residence. No other situation. No other situation. You're considered a resident. Lawfully admitted for permanent residence. Who admitted it? Mom. You. Oh, let's take a look at that 20 CFR 422.104. This is where we find that who can be assigned a Social Security number. We can assign you a Social Security number if you meet the evidence requirements. Mom admitted the evidence. She's the one that admitted the evidence into the record and said you were. And that's a presumption. Nobody can prove it. And it says you means an individual who owes a debt to the United States within the scope of this subpart, and it's 20 CFR 422.402, and we see employee benefits. The individual is the beneficiary. Do you understand? The term maintain includes maintain, collect, use, or disseminate. Quit giving it to them. Again, there are variances from categorical pretreatment standards that are fundamentally different in nature. The term record means any item. Pretty open. Pretty open. Collection or grouping of information about an individual that is maintained by an agency, including, but not limited to, his education, financial transactions, medical history, criminal or employment history, and that contains his name or the identifying number, symbol, or other identifying particular, as opposed to specific and general, assigned to the individual, such as a finger or voice print or photograph. Individual, oops, wrong one. What did I want to do? I wanted to, assigned, identify or other identifying particular assigned to the individual, such as a fingerprint, contains, is that 20 CFR 422.103? Yes it is. The one right before the previous one we just read in regards to employee benefits is the one that tells us the Social Security Administration maintains a record of the earnings reported for each individual assigned a Social Security number. The individual's name and Social Security number identify the record. It does not identify yourself. It identifies the record. You, Y-O-U, is plural, noting that there's at least two parties. The authorized representative giving an unambiguous signature on the instrument, an unambiguous authorized signature on the instrument, is therefore not liable for the person named in the instrument, because it's the instrument that is the debtor. It is the instrument that has the debt. It is the instrument that holds the debt. It also holds the credit. You just have to balance it.
And you is defined in the United States Code as someone that owes a debt to the United States.
Yeah, that's what I just showed him.
Oh, I guess I must be taking a little
20 CFR 422.104. You click on that and there's going to have a highlighted you. So you click on the highlighted you and it tells you as an individual who owes a debt to the United States. The individual is created at enumeration at birth, saying that you're a Medicare qualified government employee deemed a resident necessary by the board because you were born in the United States and now you reside in the state. It's technically an outside salesman. So the term system of records means a group of any records under the control of an agency from which information is retrieved by the name of the individual or by some identifying number, symbol, or other identifying particular assigned to the individual. The system of records is the Health and Human Services record. That's the first record that it's docketed into, and it also includes that hospital where you were born and the county register where you were born. The term statistical record means a record in a system of records maintained for statistical research. You guys feel like you're in an experiment now? A medical experiment? Is that a violation of the first 10 points of the Nuremberg Code that says the voluntary consent of the uh, subject must be voluntary, or the consent of the human subject must be voluntary? Whatever it says, it must be consensual, voluntarily. The term statistical record means a record in a system of records maintained for statistical research, and that's the Bureau of Vital Statistics, and that is the state's vital statistics jurisdiction that is created on that graph that we viewed here not too long ago. Let me pull that up for people that aren't familiar with it. And this is vital records and vital statistics in the United States, uses, users, systems, and sources of revenue. Vital records and vital statistics in the states, or in the United States, da 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 da, current birth registration process for which is a singular and individual state vital records jurisdiction, and its Bureau of Vital Statistics. So again, or reporting purposes only, and not used in whole or in part in making any determination about an identifiable individual, except as provided by Section 8 of Title 13. That's the census. The term routine use means, with respect to the disclosure of a record, the use of such record for a purpose which is compatible with the purpose for which it was collected. Statistical and reporting purposes. Oops. Reporting. Sounds like exports and imports. Again, commercial. The term matching program means any computerized comparison of two or more automated systems of records, or a system of records with non-federal records, for the purpose of establishing or verifying the eligibility of, or continuing compliance with statutory and regulatory requirements by applicants for, recipients, or beneficiaries of, participants in, or providers of services with respect to cash or in-kind assistance or payments under federal benefit programs, or recouping, such as in coupons, payments, or delinquent debts under such federal benefit programs. Again, 42 U.S. Code 2000D. Prohibition against, exclusion from, participation in, denial of, benefits of, and discrimination under federally assisted programs on ground of race, color, or national origin. Anytime, all glory goes to him. Greetings, everybody. Greetings, everybody. Thanks for joining. Lenny Malley, Professional 3-Bear, Ermias T, everybody else, greetings. Thanks for supporting us. Hit that like, share, and subscribe. So we go back to it. 2 or more automated federal personnel or payroll systems of records, or a system of federal personnel or payroll records with non-federal records. That sound like banking institutions, financial institutions, depository institutions. We're going to read about them too, folks. Let's see, what else? Is there anything else I wanted to do? I think that was the end of that.
So,
Like I said, there's
so what do you think, Keith? If there was a head to the snake locally, that would be the holder of that SS-16, wouldn't it? Who filed that?
yes,
Who is that individual?
that's that military commissioner. That's, didn't you
The
say it was
master
the sheriff?
commissioner?
Yeah, master commissioner.
Yeah.
That's the guy that's working with the birth clerk and the county registrar.
So that's the human
He's the one that's
trafficker right there in the heart of the communities.
right, but they don't
In the
know it.
heart of it.
Right, but they don't know it. Again, they've never taken down the time to study this stuff like I have. Very few people have,
Well,
and I guarantee you,
there's one in general that's got no excuse because I've been calling. So I've tried to communicate with the one there in Carrollton, and they have a lot of control there, obviously.
right. Yeah, Lenny Malley, they give you a birth certificate. What does a ship do when it docks? It comes into berth. Yeah, that's that United States vessel, 18 U.S.C. 8, or excuse me, 9, under 18 U.S.C. 8, obligations and other securities of the United States, in under 18 U.S.C. 7, in special maritime territorial transactions. That's that master commissioner. He's got to commission it as a vessel of the United States for tax purposes under the special maritime territorial jurisdiction, so that it can fall within the lines of the obligation and other security of the United States. That's all it is. It's a commercial venue.
What do you think the chances are that most of those in that position are of the opposite sex?
I'm sure there's many, and I really don't care for that, but
Yeah.
it goes to Leviticus 25 verse 44. Let me pull that up for everybody. Leviticus 25:44. Both thy bondmen and thy bondmaids. So I don't care if they're male or female. They're heathens.
Yeah.
Okay. Which thou shalt have shall be of the heathen that are round about you. Of them shall ye buy bondmen and bondsmaids. So just like any other good slave, you're supposed to treat them well, because you want them to work for you for a long time. You want them to get good at it. You want them to take good instruction from you. Hope that makes sense to you guys, because I ain't playing around no more. I'm not the slave. They are, and they will get this. They will, one day or another. Let's see here. Looking. Yeah, I don't think there was much else in here I wanted to look at. I got to cruise it just to be sure. Criminal penalties. Any officer or employee of an agency who, by virtue of his employment or official position, has possession of or access to agency records which contain individually identifiable information, the disclosure of which is prohibited by this section or by rules or regulations established thereunder, or who knowing... Say what?
You're not sharing the screen.
My apologies. Thank you. And who, knowing that disclosure of the specific material is so prohibited, willfully discloses the material in any manner to any person or any agency not entitled to receive it shall be guilty of a misdemeanor and fined not more than $5,000. That's your small claims court for if they ask me for ID. Okay? Understand, folks. If they ask me for ID, I don't have any. Well, what's your name? Well, I don't have one of those either. You're looking for a name and a number of an individual, right? Or at least a name of an individual. Well, yeah, I'm looking for your name. Well, I don't have a name. The individual's got a name, and it was attached to a number. It identifies the record. I've been called Keith all my life, and I can change what I prefer to be called. And I'm telling you, you don't call me Keith. You call me Master. You don't like it? Kiss my ass. You take my first name that is on that document and you connected it with the family name, or excuse me, the given name, and you connected it with a family name and made a legal name. I know the difference. I'm not going to give you the legal name. That's the individual you're looking for, not me. Now, if they turn around and use that and misapply that information in anything, it's a $5,000 suit, small claims. If I can push that through the small claims, guess what? Now I've got a criminal conviction I can go after in the upper courts for a tort. I ain't playing games. That's if I wanted to go to that venue. Again, I urge everybody to deal with equity. So let's continue on. Yeah, they're all 5,000. And it says, any officer or employee of an agency who willfully maintains a system of records without meeting the notice requirements shall be guilty of a misdemeanor, 5,000. Any person who knowingly or willfully requests or obtains any record concerning an individual from an agency under false pretenses shall be guilty of a misdemeanor and fined not more than $5,000. So he has to be able, in order to avoid this one with somebody like me, they have to be able to avoid the fact that I'm going to bring in the negotiable instrument and that he was in fact trying to negotiate commercial terms, which is a false pretense. I didn't give him consent to use my information for commercial terms anywhere. And every last one of these operate in commerce, not private. Got some general exemptions, Each agency record which is accepted by the Archivist of the United States. My record is not supposed to go into the United States with my private information or anything. I can agree to a statistical record if they want, but they would have to correct that statistical record and remove the resident, citizen, and all that, and relate it to a American. It would need a correction. Variance from categorical pre-treatment standards that are fundamentally different in nature. Okay. Yeah, I'm pretty sure there's nothing else. Well, let's take a look at the effect of other laws. No agency shall rely on any exemption contained in Section 552 of this title to withhold from an individual any record which is otherwise accessible to such individual under the provisions of this section. Well, again, like we've mentioned before, they're required to assist us and we can ask them anything in that record. Anything. Data integrity boards, there you go. Data integrity board, there's one. Each agency conducting or participating in matching programs shall establish a data integrity board to oversee and coordinate among the various components of such agency. That goes to the ethical standards board too. Data integrity is the ethics of making sure that the records integrity is upheld.
Again, that would be that master commissioner, wouldn't it?
Seems to be.
Yeah.
Seems to be. He's the one that's got to make sure everything's accurate before it gets entered.
Right, and he's the receiver of the funds.
Management and budget responsibilities. The director of the Office of Management and Budget shall develop and, after notice and opportunity for public comment. See, they're telling you, you have the ability to comment. You don't need to vote, folks. Just give them public comments and let them know where the record is wrong or needs to be adjusted. Applicability to Bureau of Consumer Financial Protection. Now, Bureau of Vital Statistics, again, is regulated by the Department of Commerce, and that is the purpose for which those records are created, along with the experiment and reporting. And that is what the reporting is. It's a commercial practice. Imports and exports. So let's look at the next one. 5 CFR 5.1, Civil Service Regulations. The Director, Office of Personnel Management shall promulgate and enforce regulations necessary to carry out the provisions of the Civil Service Act and the Veterans Preference Act. So you got Civil Service Act and you got Veterans Preference Act. One is talking about civil servants. The other one is talking about selective service. As reenacted in Title V, United States Code, the Civil Service rules and all other statutes and executive orders imposing responsibilities on the office. Office of Personnel Management. The director is authorized whenever there are practical difficulties and unnecessary hardships in complying with the strict letter of the regulation to grant a variation from the strict letter of the regulation if such a variation is within the spirit of the regulations. And the efficiency of the government and the integrity of the competitive service are protected and promoted. Whenever a variation is granted, the director shall note the official record to show the particular practical difficulty or hardship involved, what is permitted in place of what is required by regulations, the circumstances which protect or promote the efficiency of the government and the integrity of the competitive service, and a statement limiting the application of the variation to the continuation of conditions which gave rise to it. In other words, it's going to be an individual limitation. We can get the hardships resolved and make remedy for me, but that remedy can't be carried on to somebody else. Okay? Like variations shall be granted whenever like conditions exist. So I can help you with your grant by creating your variation if you have the same like conditions. This is the purpose of coming together and resolving our own issues. All such decisions and information concerning variations noted in the official record shall be published promptly in a federal personnel manual letter or bulletin and in the director's next annual report. This is why we need to come forth as Americans. You see very little mentioned in these codes about Americans, and we have to be able to create the variations because there are variations from categorical pre-treatment standards that are fundamentally different in nature. An American is not the same as a United States citizen. Neither is a resident. Neither is a tenant. Neither is an occupant. Neither is a dweller. Neither is an itinerant. Those are all commercial purposes. The next one I've got set up is 12 U.S. Code 1813. I wanted to talk to you about this real quick because this is the definition of deposit that we're going to look at, both in the code and the Code of Federal Regulations. Now notice they're going to be almost identical. There's going to be a slight difference. And so we're going to go ahead and read definition of deposit here. But first we're going to go through and we're going to read some of these other definitions, because this is where the depository institutions and bank and all that is going to come into play. The term bank means any national bank and state bank and any federal branch and insured branch. Includes any former savings bank. The term state bank means any bank, banking association, trust company, savings bank. Notice there's one blue line highlight. It's not separated, and it does not include trust. It just says company, comma, savings bank, comma. And it only gives you savings bank. Oh, maybe there is a separation. Yeah, I don't see it, but generally you can see a separation there. Industrial bank or similar depository institution. So a bank is a depository institution which the board of directors finds to be operating substantially in the same manner as an industrial bank or other banking institution which is engaged in the business of receiving deposits other than trust funds as defined in this section. So we go down, we see deposit. It says deposit means 12 U.S.C. 1813 L. So we'll see that in section L down below. L, deposit. The unpaid balance of money or its equivalent received or held by a bank or savings association in the usual course of business and for which it is given or is obligated to give credit, either conditionally or unconditionally, to a commercial, checking, savings, time, or thrift account, or which is evidenced by its certificate of deposit, thrift certificate, investment certificate, certificate of indebtedness, or other similar name, or a check or draft drawn against a deposit account and certified by the bank or savings association, or a letter of credit or traveler's check on which the bank or savings association is primarily liable. Remember, folks, I said there's contracts out there already, and they have a primary liability. They're passing on a liability to you as a secondary obligor, and you're accepting it. You have to fix that. That's the problem. You're taking on an obligation, and you're not supposed to. You're becoming a secondary obligor, and they're passing off all of the obligations and liabilities onto you. Provided that without limiting the generality of the term money or its equivalent, any such account or instrument must be regarded as evidencing the receipt of the equivalent of money when credited or issued in exchange for checks or drafts or for a promissory note upon which the person obtaining any such credit or instrument is primarily or secondarily liable. Now you know why you have to qualify that signature. They are taking and placing the liability on you by placing the qualification that they are the beneficiary of the rights, titles, and interest in the property because you took on the primary liability, when actually you're only a secondary obligor. You gave them an obligor number, or a number that they could change to an obligor after you signed, and that gave them the rights, titles, and interest of using any number that is relative to it, including a conversion, or for a charge against a deposit account, or in settlement of checks, drafts, or other instruments, negotiable instruments, forward to such bank or savings association for collection. Okay, so let's take a look at the next definition of deposit from the CFR, which is 12 CFR 204.2, and it says almost the same thing in a lot shorter. It says the unpaid balance of money or its equivalent received or held by a depository institution. Wait a minute. Received by a bank or savings association in the usual course of business. Depository institution in the usual course of business, and for which it has given or is obligated to give credit, either conditionally or unconditionally, to an account. Remember the sales agreement. Customer agrees to make third-party payments so long as credit is given to the customer's account. So as soon as I deposited that signature, or put that signature on there and gave it back to them, and they deposited it in their depository institution, they are now obligated to give credit if they haven't already done so. It fulfilled the terms of the contract, including interest credited, or which is evidenced by an instrument on which the depository institution is primarily liable. It's their record, and they have to provide for the integrity. So let's go back and look. Is engaged in the business of receiving deposits other than trust funds as defined in this section, and is incorporated under the laws of any state, which means you have to be incorporated under the laws of the United States, or which is operating under the Code of Law for District of Columbia, including any cooperative bank or other unincorporated bank, the deposits of which were insured by the corporation on the day before August 9th, 1989. Saving association means a federal saving association. No way around it, folks. They can't escape the federal government. The federal government is the only access, and it's all administrating the banking affairs of the individuals under the administration of the common law courts. Any state savings association, any corporation other than a bank that the board of directors and the comptroller of currency jointly determined to be operating in substantially the same manner as a savings association. And
I don't
as long
see
as
what you're reading on the screen, Keith. There you go.
And so by acting in a similar fashion as a banker, thinking you know how to bank, and you take everything to a banker and you put it in their deposit accounts, their depository institution, but you don't qualify it right because you're not a banker and you don't know how to bank. Banking is the passing or reporting of information. Nothing more, nothing less. In so doing, they are making a commercial profit off of that information. That is where the money comes from, folks. Federal Savings Association means any federal savings association or federal savings bank. State Savings Association means any building and loan association, saving and loan association, or homestead association. Any cooperative bank, other than a cooperative bank, which is a state bank, which is organized and operating according to the laws of the state, as defined in subsection A3, in which it is chartered or organized. Definitions relating to depository institutions. Term depository institution means any bank or savings association. So they're synonymous. So even though we saw a difference in the definitions of 12 U.S.C. 1813 and 12 CFR 204.2, they actually mean the same thing. Insured depository institution means any bank or savings association, the deposits of which are insured by the corporation, pursuant to this chapter. Institutions included for certain purposes. The term insured depository institution includes uninsured branch or agency of a foreign bank. And as long as you keep acting like an agent, an officer or an agent, as a resident, you're going to be considered as a foreign bank, uninsured, and you're instituted into the same thing. You guys see that? Or a commercial lending company owned or controlled by a foreign bank. They're all synonymous terms, folks. Remember, 5 CFR, what was it? 575.102. Federal government means all entities of the government of the United States. That citizen is an entity of the government of the United States. And as long as you keep professing it the way you are without qualifying it and bringing the interest of the United States into the picture, you're going to be caught up in all of the drama and all of the obligations, all of the liabilities, and you already know you have a responsibility of educating yourself. Ain't no one else going to do it. Yes, it's a rescission of the signature as a general deposit to be re-signed or reassigned as a special deposit. So let's see, what else? The next one I've got is 12 U.S.C. 614, Organization Certificate, Acknowledgement, Forwarding to, Filing, and Approval by Board of Governors of the Federal Reserve System, Permit to do business. Body corporate. Name. Deal. Corporate succession. Contracts. Suits. Directors. Officers. Employees. Bylaws. If you don't have this, and they know it, they know as a banker that you're not a Federal Reserve agent nor incorporated to handle those instruments, and therefore by when a banker gives you those instruments, you are committing a crime. by accepting them without knowing. And the banker has plausible deniability because he's just doing his job and he didn't know. Pretty wild out there, pretty wild.
You can't make this shit up.
Nope. Yeah, that's what you're doing is you're depositing an instrument with your signature on it. That's a deposit. You're depositioning it. So let's go to the next one. One we spoke about the other night. 15 U.S.C. 1601, Congressional Findings and Declaration of Purpose, and 15 U.S. Code. 15 U.S. Code relates to trust. How do we know 15 U.S. Code relates to trust? Because when we look up 15 U.S.C. 1, oops. It says trusts, etc., in restraint of trade illegal penalty. And again, that's in restraint of trade is illegal. It's prohibited to exclude Americans from participation in federal assistance programs. It's the same wording. Says the same thing in different words. So let's go back and look at 15 U.S.C. 1601, Congressional Findings and Declaration of Purpose, Informed Use of Credit, the unpaid balance of money or its equivalent in credit. And again, it's a credit card, plate, coupon book, or any device used to obtain money, property, labor, or services on credit. The Congress finds that economic stabilization would be enhanced and the competition among the various financial institutions and other firms, and we're going to show you this one here in a minute, and other firms engaged in the extension of consumer credit. That's that obligation to give or have given credit. It's a credit extension. Would be strengthened by the informed use of credit. The informed use of credit results from an awareness of the cost thereof by consumers. It is the purpose of this subchapter to assure, not insure or ensure, but assure a meaningful disclosure of credit terms so that the consumer will be able to compare more readily the various credit terms available to him and avoid the uninformed use of credit, and to protect the consumer against inaccurate and unfair credit billing and credit card practices, not laws. Again, we're still not talking law. Terms of personal property leases. The Congress also finds that there has been a recent trend towards leasing automobiles and other durable goods for consumer use as an alternative to installment credit sales, and that these leases have been offered without adequate cost disclosures. You're leasing your personal services. Again, you're acting in the same fashion as other people, and you're signing these documents, and that's a personal service. It's a service for a service. It's equal consideration. They too will sign, as you already know, if you don't qualify your signature. It is the purpose of this subchapter to assure a meaningful disclosure of the terms of leases of personal property for personal, family, or household purposes. The lease of the personal property is that name. You leased your personal property, the given name and the family name. You leased it so they could create a legal name and attach a number so they could give you a credit card. The Social Security card is a card, and it says credit card. Any card, plate, coupon book, or device used to obtain money, property, labor, or services on credit. You don't have money to use, folks. It's a balancing of the books, and you do so by giving directives, so as to enable the lessee to compare more readily the various lease terms available to him, limit balloon payments in consumer leasing, enable comparison of lease terms with credit terms. See, they give me a lease agreement. I line item vetoed lease and put in credit. Line item veto resident sojourn. Line item veto occupant, no occupation. Line item veto tenant, not a tenant in lieu of the landlord. It's a usufruct. And they're saying I'm using the landlord's property as a tenant. No, I'm not. I'm not a tenant in lieu of the landlord. I'm here dwelling or passing through in a temporary sojourn, and I'm resting with my Father. This is a temple. It's not a residence. And they cannot allow for those terms to be used if I say otherwise, by clarifying those terms as used in their code. Occupant, someone who is living or using a premises or property as a tenant or owner, or someone has occupancy of a premise or property. Does not need to be a tenant or owner, but can be someone living or using a property with the intention of acquiring ownership. Tenant, a person or entity.
Share screen.
Yeah, no, I'm not on it. This is actually terms that I'm bringing up for lease, and I just thought I'd mention it. But it's just a matter of fixing the terms in those agreements. Lease agreement, nope. Credit agreement lets them know right from the start we're going to extend some credit and not use money or other instruments that aren't qualified. The next one, I've got a Justia, Iowa, or Justia, U.S. law. Determine of finance charge, except as otherwise provided in this section. The amount of the finance charge in connection with any consumer credit transaction, not the extension of credit, but a consumer credit transaction, shall be determined as the sum of all charges payable directly or indirectly by the person to whom the credit is extended, and imposed directly or indirectly by the creditor as an incident to the extension of credit. The finance charge does not include charges of a type payable in a comparable cash transaction. Nope. Does not include charges of a type payable in a comparable cash transaction. That's all that paper that everybody calls money. It's cash, right? It's not money. And
Hey,
it's not credit. Examples of charges which are included in finance charge include any of the following types of charges which are applicable. Interest. The United States has an interest on the obligation of a debt. Time price differential and any amount payable under a point, discount, or other system or additional charges. Service or carrying charge. That's service charge. Examples of charges which are included in the finance charge are service or carrying charges. Go back and listen to the terms we just read. It spoke about both of those, service and carrying. Carrying an obligation. Loan, fees, loan fee, finder's fee, or similar charge. Fee for an investigation or credit report. Premium or other charge for any guarantee or insurance protecting the creditor against the obligor's default or other credit loss. Do you get that, folks? Premium. You pay an insurance premium, don't you? What's your insurance premium? That's your monthly payment, and you pay it every fucking month. Why? The finance charge pays it. What's a finance charge? Covers all the fees. Life, accident, or health insurance premiums included in finance charge. Charges or premiums for credit, life, accident, or health insurance. What's life insurance? It's credit life insurance. What's accident insurance? It's accident insurance. What's health insurance? It's health insurance. But life insurance is actually credit life insurance because you already earned credits and it shows in your life on the record that you worked under an employment scheme and earned insurance credits that are lodged, held, carried, serviced by Social Security Administration. Written in connection with any consumer credit transaction shall be included in the finance charges unless. Did mom have a credit transaction when she went to the hospital and registered to give birth for inpatient hospital services while she was carrying her baby and was in labor and then discharged the legacy heir from her waters, but turned around and gave it a name, a legal name? The coverage of the debtor by the insurance is not a factor in the approval by the creditor of the extension of credit. And this fact clearly disclosed in writing to the person applying for or obtaining the extension of credit. And in order to obtain the insurance in connection with the extension of credit, the person to whom the credit is extended must give specific, affirmative, written indication of his desire to do so after written disclosure to him of the cost thereof. In order to obtain the insurance in connection with the extension of credit, the person to whom the credit is extended must give specific affirmative written indication of his desire to do so after written disclosure of him of the cost thereof. So remember the sales agreement? Customer agrees to pay the stated price for equipment, it being understood that credit will be given to the customer's account for payments received from any medical insurance program or from any third party. Guess what? I'm both the creditor, consumer, customer, third party. I'm not involved in the specific contract. The legal name is. It's the beneficiary. It's holding the credits. So I extend those credits to the institution as my form of payment, and they're supposed to then turn around and make sure it's understood that credit is given to the customer's account. Guess what? That means I don't receive any federal funding. It means they get credit, and then when they get done using those credits go back. Equal consideration, equal benefit. Agree. Everything going on in court is about creditor-debtor relations via contract, nothing else. Form AO 430, and this is one thing I'm going to assure you. You cannot dismiss it. It's all the administrative office of the United States Court, case information record.
Screen.
And look what they do here. Case information record, administrative office of the United States Courts. Look at this stuff here. What is this stuff saying? It says in this little box here on the left-hand side, which is the debit side, says plaintiff, other, and government, along with debtor. It's recognizing that plaintiff, other, and government are of like kind with debtor. Defendant, other, creditor. Again, in this box, it's showing these three parts of like kind. Other, defendant, creditor. Benefactor, trustee. Look at this here. District judge, bankruptcy judge, magistrate judge, other, specify. Chancellor. Type of proceeding, equity. While remembering that they have an obligation to assist Americans. What do you think, Russ? Pretty good show tonight?
Absolutely. Absolutely. You know, I'm always fascinated. It shouldn't be that difficult to even get these guys to even want to take a look at it locally. You know what I mean? No one seems to want to entertain any of this information.
Well, and I got to say, Harry Nutt, again, equity follows the law. The law is of contract. So in order to come up with your own equitable remedy. You have to be able to create a contract yourself to be able to contract your privacy to stay out of the public forum like that. It's private relief law. It's literally you're making a contract with the government, a fidelity agreement, and you're using the very same insurance credits that is already a fidelity agreement in a different form and going through a salvation process so you can resurrect it and merge it in a new name. That's what you do with all new vessels or salvaged vessels. You christen them. No one christened you in the enumeration at birth. Sounds odd, doesn't it? But that's exactly the way it works in my discernment. As my research has showed me, you got to be able to walk in and show them you know how to contract by learning the terms and conditions of the contract so you can literally change them yourself to provide the remedy of the very variances that they need to be informed of. Variances for variances from categorical pretreatment standards that are fundamentally different in nature. So think about that stuff. And if you've got anything else to say before we head out, Russ, please do so.
Yeah, no, I mean, most of it, I just try to look for ways to simplify how to move through all of this. You know what I mean? To just totally simplify things. And I think if we've been taught that we're U.S. citizens and residents and all these terms, and if we can get rid of that and just realize we're Americans and only go off of that with equity in communications with these people moving forward, it would be some major change.
Right. And it's the American people that are supposed to be the benefactors or beneficiaries, however they want to play that game. I call it benefactor because that's truly what it is. Then it's to your own interest and to your own benefit to be able to learn this stuff so you can clarify it because they're never going to learn it. They're only going to learn their job. They're not going to learn the variances. They're going to learn the guideline, strict, delineated terms and conditions that they've always been using. And so when we try to rebut tenant, occupant, lease, and all that stuff, they're going to be confused. But
right.
They've got to understand that if we're the benefactors, they're the trustees, and they have that obligation, like we saw at the very beginning. The following the principles, basic obligation. Each employee has a responsibility to the United States government and its citizens to place loyalty to the Constitution. That's what's telling us that is a contract in trust. And anybody following that Constitution for their corporate laws and stuff, whether it be the mom and pops, the gas station, the courthouse, or whatever, it's all contract terms and conditions to implement those statutes, codes, or statutes or executive orders for their commercial transactions and all that shit. So.
And it would seem that all the ones that are partaking in these government agencies they've been programmed by these codes. But their discernment of these codes in some sort of way, they've been programmed outside of equity and have these self-righteous tendencies or whatnot inside themselves. I mean, Look at how fascinating all of this shit is, really, if you really get down to dissecting things.
Yeah, and that's another one. People hear equity and they think money, and that's absolutely not true. That's one of the issues we have with equity is if you try to push equity in an administrative court, they always want you to put down some kind of compensatory damages. That's not what we're seeking. We're not looking for money. We're looking to be left alone so we can profit our own value. This is the profit unto the nation. So it's really a matter of looking through those codes, find out what it means, so you can learn how to avoid them, and at the same time hold them to their obligations, liabilities, responsibilities, and stuff. So, and again, it's not so you threaten them, but just to give them some education so that they're aware that they're on a grave grounds. You're the one that's undertaking these liabilities, and I'm just trying to correct the record. And if you continue not to allow me to correct those terms and conditions that are implemented in those statutes, codes, and stuff that you're using, then you're misapplying them, and that's a 30-year sentence.
That's it.
Yep, another one, Harry Nut. Real equity is a jurisdiction of compelled performance. We're not trying to threaten them. We're just compelling them to do what they ought to do, because if they don't, they might be held liable by their the head of the agency for their not following the designated powers as appropriately. So, and with that, we're out.
You know, one more thing before we go. What I've seen, you know, in that researching those master commissioners, they're actually above the sheriffs and all. I mean, the whole deal. They're, I mean, they've got the whole game.
Yep. Well, everything's got to
Locally.
be commissioned. Everything's got to be commissioned. That's that Fifth Amendment, where they can't take your property without military necessity, and they got to compensate you for it.
So they pretty much run the sheriff's office, the county, and the city.
Well, let's take a look at Article 10 of the Lieber Code. That's what I was talking about earlier. And Article 10 of the Lieber Code tells us that martial law affects chiefly the police and collection of public revenue and taxes, whether imposed by the expelled government or by the invader, and refers mainly to the support and efficiency of the Army, its safety, and the safety of its operations. I'm telling you, look at that flag in the courtroom. It is a military flag of martial courts.
Absolutely.
All right. With that, we are done. You got anything else?
No, I think I'm good. I'll end with the same thing as always. Be the change you wish to see, people.
Awesome.
Many blessings, and much love, Keith. It's a pleasure.
Absolutely. You too, brother. And with that, guys, you know me. I love you. I don't give a rat's ass whether you love me back or not. And that's to say, I don't care if you hate me. So may God bless you, and have a good night.